Welcome to the first event of this year for the NYU program on corporate compliance and enforcement. It is my great honor and pleasure to welcome Sally Quillian Yates, the Deputy Attorney General of the United States, to speak to you today about individual liability for corporate wrongdoing. Deputy Attorney General Yates has had an illustrious career, one devoted primarily to public service. Prior to assuming her current position on May 13th of this year, Ms. Yates was the United States Attorney for the Northern District of Georgia. There, she oversaw an office of more than 175 lawyers and support staff. She also served as Vice Chair of Attorney General Eric Holder's Advisory Committee, providing counsel on national enforcement policy and practice. A veteran prosecutor with over 25 years of experience, Ms. Yates is an expert on today's topic, white-collar crime and public corruption. She served as chief of the Fraud and Public Corruption section of the Northern District of Georgia. Later, she was promoted to first Assistant U.S. Attorney in the Northern District of Georgia. During her tenure, she was the lead prosecutor in the Atlanta prosecution of the Olympic bomber, Eric Rudolph. In addition, and more closely related to today's subject, Deputy Attorney General Yates pursued successful corruption prosecutions of Atlanta City Mayor Bill Campbell, along with 11 city officials and contractors. Ms. Yates' speech today promises to shape enforcement practice governing white-collar crime and corruption for years to come. Please give a hearty welcome to Deputy Attorney General Yates.
Good afternoon, everyone. And thank you, Professor Arlen, for that kind introduction and for everything that you and your colleagues are doing here at NYU. And the few years since its launch, the program on corporate compliance and enforcement has really made its mark, not just here in New York, but really across all of the country, and provides a much-needed venue to explore both the causes of and some of the potential solutions to corporate misconduct. It's an honor to be joined here today by so many prominent leaders in the world of law and corporate compliance, including several of our federal judges, a number of DOJ officials, including U.S. attorneys, and would like in particular to recognize some of our local U.S. attorneys, Paul Fishman, the U.S. attorney from the District of New Jersey, Kelly Curry, the U.S. attorney from the Eastern District of New York, and Deidre Daly, the U.S. attorney from the District of Connecticut. All of them have done really terrific work in the area of white-collar prosecutions. I also particularly want to thank Dean Morrison and the entire NYU community for hosting us here today. 26 years ago, I started as a line assistant United States attorney in the U.S. Attorney's Office in Atlanta. And as Professor Arlen said, I have been with the Department of Justice ever since. During that time, I've had the opportunity to participate in white-collar prosecutions from a number of different vantage points, from as an AUSA cutting subpoenas, to as a supervisor reviewing plea agreements and charging documents, and then later as U.S. attorney. Since becoming Deputy Attorney General, I've been able to view white-collar prosecutions from a wider lens, and certainly all of these experiences shape my perspective on white-collar enforcement priorities. From these experiences, I have learned what many of you know, and that is that there are some unique challenges for DOJ agents and attorneys in complex corporate criminal cases. There are complex hierarchies, there are enormous volumes of electronic documents, and a variety of legal and practical challenges that can limit the access to the evidence that we need. But in its most basic ways, though, corporate misconduct isn't really all that different from everything else that DOJ investigates and prosecutes. Crime is crime. And it's our obligation at the Justice Department to ensure that we are holding lawbreakers accountable, regardless of whether they commit their crimes on the street corner or in the boardroom. In the white-collar context, that means pursuing not just the corporate entities, but also the individuals through whom the corporations act. Few people understood this better or were more committed to ensuring equal justice than our former Attorney General, Eric Holder. Last September, he spoke forcefully here at NYU, discussing the many reasons why individual accountability in corporate cases is so important. He talked about that it deters future illegal activity because it incentivizes change in corporate behavior and because it ensures that the people who engage in the wrongdoing are held responsible for their actions. He made clear that as a matter of basic fairness, we can't allow the flesh and blood people responsible for the misconduct to walk away while leaving only the company's employees and shareholders to pay the price. And he pointed out that nothing discourages corporate criminal activity like the prospect of people going to prison. But former Attorney General Holder was also frank about the challenges that we face pursuing financial fraud cases against individuals. In modern corporations where responsibility is often diffuse, it can be extremely difficult to identify an individual person or groups of persons who possessed the knowledge and criminal intent necessary to establish proof beyond a reasonable doubt. This is particularly true of high-level executives, who are often insulated from the day-to-day activity in which much of the misconduct occurs. Without an inside cooperating witness, and preferably one identified early enough to be able to wear a wire, investigators are often left to reconstruct what happened based on a painstaking review of corporate documents, looking for that smoking gun that most white-collar criminals are far too savvy to leave behind. And since virtually all corporations now operate worldwide, restrictive foreign data privacy laws and the limited ability to compel the testimony of witnesses abroad make it even more challenging to obtain the evidence that we need to bring individuals to justice. But regardless of how challenging it may be to make a case against individuals in corporate fraud cases, it's our responsibility at the Department of Justice to overcome these challenges and to do everything we can to develop the evidence necessary to bring individuals to account. Americans should never believe, even incorrectly, that one's criminal activity will go unpunished simply because it was committed on behalf of a corporation. We could be doing a bang-up job at everything at the Department of Justice. We could be bringing all the right cases and making all of the right decisions. But if the citizens of this country don't have confidence that our criminal justice system operates fairly and applies evenly, regardless of who commits the crime, then we're in trouble. This issue has been at the front of my mind since coming to Washington 8 months ago, and I know the same is true of our Attorney General, Loretta Lynch, who also cares deeply about this issue. And most importantly, it has been on the minds of the talented men and women of the Department of Justice who do the hard work to make the cases. Over the past months, a group of experienced lawyers from all across the department, and including the U.S. Attorney's offices across the country, have examined how we approach corporate investigations. They ask themselves, how can we overcome these challenges and maximize our efforts to make the strongest possible cases against individuals involved in corporate wrongdoing? Throughout the recent working group process, they've demonstrated a determination to adapt our practices to evolving demands. In taking on this project, we analyzed our civil and criminal investigations and thought carefully about what we should do at the Justice Department to ensure that individual accountability is at the heart of our corporate enforcement strategy. And so, based on this work, we're taking 6 specific steps to hold individual corporate wrongdoers accountable. These steps are the subject of a memo that I issued yesterday to all of the department's prosecutors and civil litigators. And I'd like to discuss these 6 steps with you today. Some of these steps are institutional policy shifts that change the way we investigate and charge and resolve cases. Some address the way that the Department of Justice interacts with targets of the investigation. Some of the policies are new, and some are already being practiced by some prosecutors and components in U.S. attorneys' offices across the country. But fundamentally, These new policies ensure that all department attorneys, from Main Justice to the 93 U.S. Attorney's offices across the country, are consistently using our best efforts to hold individual wrongdoers accountable. To codify and to supplement these changes announced in yesterday's memo, we're going to be revising the guidance documents that our attorneys traditionally rely on when investigating cases of corporate misconduct, and this includes the U.S. Attorney's Manual and the Principles of Federal Prosecution of Business Organizations, more commonly referred to as the Philip Factors. The first change relates to one of those Philip Factors. Effective immediately, we have revised our policy guidance to require that if a company wants any credit for cooperation, any credit at all, it must identify all individuals involved in the wrongdoing, regardless of their position or status or seniority in the company, and they must provide all relevant facts about their misconduct. It's all or nothing. No more picking and choosing what facts to disclose, no more partial credit for less than full cooperation. Now, to the average guy on the street, this might not really sound like much of a big deal. But for those of you who practice in the white-collar area, you'll recognize that it is a substantial shift from our prior practice. While we have long emphasized the importance of identifying culpable individuals and providing information about those individuals, if a company is going to cooperate with the government, we have stopped short of saying that you get absolutely no credit for cooperation otherwise. And so we had companies who would cooperate with us. They would perhaps voluntarily disclose information. They might provide documents, but they would stop short of identifying who the culpable individuals were and giving us all of the facts about those individuals. And in the prior practice, while those companies were not entitled to full credit for their cooperation, they still got some credit, which could be enough to be able to avoid indictment. Well, the rules have just changed. Effective today, if a company wants any consideration for its cooperation, it must give up the individuals no matter where they sit within the company. And we're not going to let companies plead ignorance either. If they don't know who is responsible, they'll need to find out. If they want any cooperation credit, they'll need to investigate and to identify the responsible parties and then provide all non-privileged evidence implicating those individuals. While this is new for the corporate world, there's really nothing radical about this concept. It's the same rule that we apply to cooperators in many other types of criminal prosecutions. A drug trafficker can decide to flip against his co-conspirators. He can proffer to the government the full scope of the criminal scheme. He can take the stand and testify for the government against a dozen street-level dealers. But if he has information about the cartel boss and he declines to share it, we rip up his cooperation agreement and he serves his full sentence. The same is true here. A corporation should get no special treatment as a cooperator simply because the crimes took place behind a desk. This position builds on the tremendous work advanced by Leslie Caldwell, our Assistant Attorney General for the Criminal Division, since she returned to the Department of Justice last year. Leslie and the Criminal Division have been demonstrating that corporate cooperation can and must focus on individual accountability. And our new policy guidance that was issued yesterday now makes that crystal clear. This threshold requirement of complete cooperation as to individuals not only governs criminal investigations, but civil investigations as well. Companies will be expected to provide the same type of information about individuals if they want any consideration in the resolution on the civil side, including how a case is charged or resolved and whether we bring the action against a parent or against a subsidiary. Similarly, it will be the department's position going forward that in order to qualify for the reduced damages provision of the False Claims Act, the company must identify all culpable individuals and provide all material facts about those individuals. Now, this new cooperation requirement doesn't mean that DOJ is going to sit back and wait for the companies to deliver information about individual wrongdoers and then merely accept what the companies provide. To the contrary, department lawyers will be actively investigating the activity at every step of the process, both before, during, and after any corporate cooperation. And we will be vigorously testing the information provided by companies. And we're going to be comparing it to the results of our own investigation. Building on this point, a company should not assume that its cooperation ends as soon as it settles its case with the government. Going forward, corporate plea agreements and settlement agreements will include a provision that requires the company to continue providing relevant information about individuals implicated in the wrongdoing. A company's failure to continue cooperating against the individuals will be considered a material breach of the agreement and will be grounds for a revocation of the agreement or stipulated penalties. And one final note on this point. The whole purpose of this policy is to better identify the responsible individuals, not to burden corporations with unnecessarily long or expensive investigations. We're not asking companies to boil the ocean, so to speak, and to embark on a multi-million-dollar investigation every time they learn about misconduct. We expect a thorough investigation that is tailored to the scope of the wrongdoing. So for all the defense attorneys in the room, and I know from the reception earlier, there are several of you here, if you are representing a company and you have a question about the scope of what's required, you should do what many defense attorneys do now, and that is to pick up the phone and consult with the prosecutor. As part of this broader policy shift, we're not just changing what we expect of companies, but we're also changing what we expect of ourselves. The second policy I want to discuss involves how we initiate and develop corporate investigations. One of the things that we have learned from experience is that it is extremely difficult to build a case on individuals, civil or criminal, unless we focus on those individuals from the beginning. So, for example, if a case is initiated as a civil investigation and documents are gathered and individuals are interviewed with an eye toward establishing corporate civil liability, it's really extremely difficult at the end of that process to then go back and to try to build a criminal case on individuals after the civil investigation is over. And that's for a variety of reasons. It's not just the passage of time, but of course the level of intent that's required in a criminal case is much higher than that required in a civil case. And so to address this problem, we're instructing our attorneys that going forward, they are to focus on individuals from the very inception of the investigation, regardless of whether this investigation starts as a civil case or as a criminal case. Moreover, once a case is underway, the inquiry on individual misconduct can and should proceed in tandem with the investigation of the broader corporate investigation. Delays in corporate cases will no longer suffice as a reason to delay the pursuit of individuals involved. The third policy really dovetails with the second. The best way to ensure that criminal and civil prosecutors don't need to go back and build a new case once the other investigation is over is to ensure that everyone is talking to each other from the very beginning. And so we are directing our civil and criminal attorneys to collaborate to the full extent permitted by the law at all stages of the investigation and from the very beginning. The Department of Justice has access to a wide range of enforcement remedies, from civil penalties to lengthy prison sentences, and the only way really to leverage our full authority is by ensuring early and regular communication. To make sure that nothing falls through the cracks, we're formalizing these lines of communication. So going forward, regardless of whether a corporate case begins as a civil inquiry or a criminal inquiry, the DOJ attorneys initially handling the matter will be responsible for notifying the other side of the house. And as the case proceeds, civil and criminal attorneys will be in regular contact. If the prosecutors decide that charges against individuals are not appropriate, they'll need to notify their civil counterparts so that they can make an independent assessment of civil liability. And if civil attorneys identify that an individual should be investigated for criminal wrongdoing, they will be expected to promptly notify the criminal prosecutors regardless of the current status of the civil investigation. The fourth and fifth policies relate to how we resolve cases. As I mentioned earlier, delays in corporate investigations should not delay our ability or our willingness to resolve cases against individuals. In most instances, this is going to mean that we're resolving cases with individuals before or at the same time that we are resolving the matter against the corporation. But if DOJ attorneys decide that it's necessary to resolve the corporate case first, they will only be permitted to do so once they have demonstrated a clear plan to their supervisors for resolving the related individual cases, and to have that plan be one that it can be completed before the statute of limitations expires. If at the conclusion of the investigation, the DOJ attorneys decide not to bring charges against individuals, they'll be expected to memorialize their justification for this and to obtain approval either from the U.S. Attorney or the Assistant Attorney General who is overseeing the investigation. Likewise, we are instructing our attorneys that they should not release individuals from criminal or civil liability when resolving a matter with a corporation, and this should happen in the rarest of circumstances. When those circumstances do arise, the litigating attorneys will be required to get written approval again, either from the U.S. Attorney or the Assistant Attorney General who will be overseeing that case. 6, and finally, we are broadening our civil enforcement strategy. Generally speaking, when a criminal prosecutor is deciding whether to bring charges against an individual, he or she consults with the principles of federal prosecution that lays out a number of considerations, including the nature and the seriousness of the offense, the impact of the crime on the community and its victims, as well as the history of the individual. While some of our civil litigators have routinely pursued individuals, others have not, primarily because they have focused on the financial resources and the ability to recover from their investigative targets. This is an understandable practice given that monetary sanctions are the most common form of relief in civil cases. But the result of this was that it naturally prioritized large-scale corporate investigations on the civil side over individual actions and looking at individuals who were involved in wrongdoing. There's real value, though, in bringing civil cases against individuals who participate in corporate misconduct, even if that value can't always be measured in dollars and cents. Civil enforcement actions, like criminal prosecutions, hold wrongdoers accountable for their actions, and they deter future wrongdoing. While we may not be able to satisfy the entire judgment with an individual's resources, if that individual is liable, we can take what they've got, and we can ensure that they don't benefit from their wrongdoing. These individual civil judgment will also become part of the corporate wrongdoer's resume that will follow them for the rest of their careers. And by holding individuals accountable, we can change corporate cultures to appropriately recognize the full cost of wrongdoing, rather than treating liability as a cost of doing business, a change that will protect public resources over the long term. Beyond that, our civil attorneys recognize that they have an obligation not only to protect the public fisc, but to protect the public itself. So, going forward, we'll be pursuing civil actions against corporate wrongdoers, even if those wrongdoers don't necessarily have the financial resources to satisfy the full judgment amount. And our civil lawyers will be looking at factors that are very similar to those that our criminal prosecutors look at and determining whether to bring individual civil actions. An individual's financial resources will now only be one of the factors that will be considered in determining whether to go forward individually. We're going to continually re-examine our practices to ensure that we're doing everything that we can to hold corporate wrongdoers accountable. Despite this, there are still going to be cases where we don't have the evidence necessary to establish criminal intent, and certainly that we don't have the evidence to establish criminal intent beyond a reasonable doubt. And regardless of public demand, we will never bring charges against anyone unless we are satisfied that that individual is in fact guilty of a crime. That's the core of our responsibility and our promise to the American people. And I should be clear that while these policy shifts are effective immediately, the public won't see the impact of these steps overnight. Some of these policies will affect cases that are only just beginning now and may not be public for several years. In the coming weeks and months, we're going to be providing additional training to our lawyers within the Department of Justice, and specifically next week, We have a training course for civil and criminal litigators that's designed to talk about these policies and how we can most effectively implement them and how we can take other steps to ensure we're doing everything we can to hold individual wrongdoers accountable. We're making these changes recognizing some of the challenges that they're going to present. Some companies may decide that the benefits of consideration for cooperation with the Department of Justice, that they're just not worth coughing up the individuals. Less corporate cooperation could mean fewer settlements. It could potentially mean smaller overall recoveries by the government. In addition, individuals facing long prison terms or large civil penalties might be more inclined to roll the dice and go to trial and take their chances before a jury. Only time will tell. But if that's what happens, so be it. Our mission is not to recover the largest amount of money from the greatest number of corporations. Our job is to seek accountability from those who break our laws and victimize our citizens. It's the only way to truly deter corporate wrongdoing. At the Department of Justice, our ability to fulfill our responsibilities, to advocate for victims, and to vigorously pursue misconduct, to seek justice in all its forms, depends on public confidence in the institution that we represent. But the public's confidence is not something to be assumed or expected. It's something that we have to earn and that we have to vigorously protect every single day. We do that by pursuing wrongdoing, no matter who those wrongdoers are. The men and women of the Department of Justice have always embraced this challenge, both as an opportunity and as a privilege. And once again, we embrace the task that is presented to us today. There is only one system of justice, and it demands that all be held accountable for their wrongdoing. We look forward to the work that we're going to be required to do to seek greater accountability from those who use corporations to lie, cheat, and steal. It won't always be easy, but we're ready for it. Our nation and its citizens deserve nothing less. Thank you.
We want to thank Deputy Attorney General Yates for that very stimulating and interesting talk, which I know will be reverberating through many practice areas for years to come. We have copies of the memo available in the back, and the Deputy Attorney General will not be taking questions, and I want to thank you all for coming.